Okay, so we're jumping straight into the deep end. Miss Stringer is already in front of a judge, and we're talking about 2 added charges plus a $500 restitution request. Before she even says a word, her attorney is already flagging Michigan compiled laws on the record. Why does that matter? Because in a guilty plea, the exact statute has to be correct. Get the McLittle wrong, and the whole plea could be defective. The defense isn't being difficult, they're doing their job. Watch how this unfolds.
Attempted illegal entry, that's a 46, and they got to be listed. Or 46.
Yeah, and that's 750115A.
And then the Ash Capital making it.
Okay. All right, and there's also a request for restitution of 500.
Yes.
All right. All right, Ms. Stringer, did you discuss your rights and options with counsel? You understand those rights and the options they present to you? You understand the possible penalty for these 2 added charges? Are you pleading guilty to those 2 added charges today?
Yeah, Judge, just a moment, regarding the MCL, just before she admits guilt.
Yeah, that's all right.
So I think for the malicious destruction of property, that's a 750.386.
It's not fine.
So 5 is still a 1-year misdemeanor. 6 is the under 200, that's the 93.
Okay, I made that correction.
And
Catching it?
for the 750.115, I just wanted to double check the A, because that's not what I had. I think it's without the A, 750.115. One.
Ash A and then capital.
Ms. Stringer, you can sit down. They make the attorneys talk on their feet in law school, so it's okay.
B
was
illegal entry is 115-A.
dash
And
A.
then we'll put the A for the attempt.
Okay, no problem with that, but yes, the
Okay.
first question.
It was each right for one.
All right. So, understanding all that, Ms. Stringer, are you pleading guilty to these charges? Are you doing so freely and voluntarily today? All right. Counsel, would you like to board here to get the facts that support the pleas?
Yes, I would, Your Honor.
I've shown an incident date here, Romulus, April 28th this year.
So, Ms. Stringer, so I'm going to take you back to April 28th, 2026. On that date, did you visit the address of 15085 Mesa Way in Romulus?
Yeah.
And is that in Wayne County, Michigan? And on that day, did you walk up to the door of that house and start knocking on that door? At some point, did you use your foot to strike the door?
I can't hear. I heard yes, and then I didn't hear what the rest was. Okay.
And
Hold on, did you catch that? The attorney just switched from a guilty plea to a no contest plea, and the judge had to stop everything to explain why that still matters. Here's the key legal distinction. A guilty plea is an admission of fault. A no contest plea or nolo contender means I'm not fighting the charge, but it's not an admission of guilt. It can't be used against you in a civil lawsuit later. Smart move by the defense, especially when the defendant seems foggy on what actually happened. The judge handled that pivot like a pro.
in so doing, did you cause even a slight amount of property damage? Unknown. I mean, I think there might be some memory issues here, so I also would have no problem with the contest plea.
Your Honor, I'm going to subscribe to that.
I'm all right with that. Hold on. You understand if you say no contest to the charge, you're literally saying, Judge, I'm not fighting that charge. So if I find facts that support the plea, we go forward and there's a sentencing. You understand that?
My client is okay with the no contest plea.
Okay.
And
You satisfied with the facts, Mr. Kaplan?
Yes, Your Honor. This report reflects that on the date shown in the complaint judge, this young lady, the defendant, visited a home, not her own, caused a slight amount of damage to the front door, and also tried to enter the home unsuccessfully without permission.
Satisfied?
that's-
I am too. I'll dismiss the original count one. I'm inclined to send her for a pre-sentence investigation, but I'll let you try to talk me out of it.
What I feel, if I may, is that this was an isolated incident. It was actually a mistake. I think maybe she was associated with a bad hombre somewhere, but at any rate, she seems to be doing well. I think you did set the state.
I agree, Judge.
Okay.
There's this $500 restitution that's set there. I believe that you can come up with a reasonable probation on the spot and speak.
Okay. All right. Go ahead.
Your Honor, Ms. Stringer is 20 years old. This is her first contact time system. Like Mr. Calvin said, I think this was an isolated incident. She has worked before. She's looking for work now. I think this pending has made it difficult for her to secure her next job. She intends to, re-enter the workforce.
Okay.
We're grateful for the misdemeanor reduction. Hope that these offenses get expunged sometime soon. In the meantime, Your Honor, we would ask for simply imposing the restitution that was in the agreement. If there would be any probation, that it be minimally intensive. She lives in Taylor,
Yep.
so not exactly stone's throw away. So I would just ask that any probation be limited to, a few check-ins, maybe, alcohol test.
Gotcha.
Intensive classes, or anything like that.
We agree on it.
All right. Thank you. All right. Ms. Stringer.
Here's something you don't see every day, a judge pausing sentencing to personally refer a 20-year-old defendant to a job placement resource in the courthouse. Let that sink in. This isn't just about punishment. This judge is looking at a first-time offender, someone trying to re-enter the workforce, and thinking, what actually helps this person not come back? This is what they call a problem-solving judicial philosophy. It's rare, it's thoughtful, and honestly, it's kind of remarkable.
Where did you work last time you had a job? Who were you working for? How long were you there?
It started like 2-3 weeks before.
Okay. How about the job before that? What were you doing? Okay. All right. So this is a little bit off topic, but before you leave my building, go downstairs and ask if Mr. Taylor's still here. He shouldn't be at lunch yet. Ask Mr. Taylor what he's got for job opportunities in the area, like Romulus or Taylor. He keeps track of job openings for like entry-level jobs. He's usually got a pretty good list, so something might reach out to you. All right, anything else you want me to know before I sentence you today? No? I can't hear you. Okay. All right. So I've got a problem with these restitution orders. Do you have the ability to pay $500? Not today, but I mean, can you get this paid in the next 5 months, 6 months? You sure? All right.
Right on the average, yeah.
Yeah.
We recommend a $300 restitution.
$300?
Amorphous as to how much damage.
All right. It's your recommendation. I'll take it.
Thank you.
She's not going to argue with you. All right. So you can get that done? Okay. Was there any indication there was some kind of substance abuse involved in this?
No, don't do so, Judge. Thank you.
You got a driver's license, your valid license to hold on yards? Okay. All right, well, the $300 has got to be money because that's restitution. I'll give her the option. I could do some community service or I could do some work program time instead of fines and costs. She's not working right now. She just have to be here at 8 o'clock in the morning. She picks the days.
Would that be work program as opposed to community service?
Well, I like work program because then she walks out of here. She knows she's got a schedule for X number of days. She bangs those days out. She doesn't have to worry about finding someplace to go. She just shows up here and does it. I'll give her fines and costs and give her time to pay.
Could we just do one in lieu of the other so she can kind of choose what works best for her after today?
Sure. Reasonable. All right, so here's what I'm going to do on 750.3806. Well, first of all, on both charges, it's 12-month non-reporting probation. That just means stay out of trouble. On the first count, which is the 3806, that one, I'm going to put the restitution on that file and $400 fines and costs or 4 days on the court work program. On the attempt illegal entry, it's another $400 fines costs or 4 days on the work program. What I'm inclined to do, counsel, is give her until June 12 on the first file to do the money or the work days, and then give her until July 15th on the second file. So that way she just knows she's got 30 days to either do the $400. In any event, she's got to get the 300 paid, but she's got the first file, she's got 30 days to do the 4 days or the $400, and then she's got another 30 days to do another 400 or another 4 days. And if she wants to pay 4 and do 4, however she wants to work it out. Does that make sense? Sure.
All right, take a breath, because that sentence was actually pretty creative. Non-reporting probation, staggered payment deadlines, a work program option as an alternative to fines. The judge essentially built her a choose-your-own-adventure path to compliance. No jail, no excessive supervision. Just, here are your deadlines here. Are your choices. Don't mess it up. Now we're pivoting hard to a completely different case, the Phoneville case, and I promise you, things are about to get significantly more complicated.
You got the bodies we need for the next one?
That we appreciate, court's, assessment here. Is it possible just to give a little bit more time? What if we just make it like a, instead of a 30, 60 day, make it a 60, 90 day situation?
No, I'm not going to wait that long to find out I got a problem. If she wants to say, I'll do the money, then we'll just put her on a payment plan on the money. If she can't make the decision today, I got to limit it. But if she wants to make the decision today, money or time, then we can work with that. But why don't we pass on this so I can call another file? You guys take all the time you need. Fonville.
That's it, you, sir. David Champagne.
Appearances on the People versus Fonville, please.
Or Sandy Allen on the other people around.
Good morning, David, the defender service by action number P87788 on behalf of Mr. Fonville. Mr. Fonville, can you please say your name?
Joseph Fonville.
Thank you, sir. What do we got?
Then we're ready to proceed. We are seeking respectfully to call Denise Fisk by Zoom. Judge, in this case, Ms. Fisk is not in the state, he's outside of the state. The court rule, Judge, I know you're familiar with it, the criminal court rule gives your honor absolute discretion to allow testimony by Zoom, and you know that, I know. The only stipulation on the mandate is that the defendant either attend court or refuses to attend court.
Right. Counsel.
Your Honor, at this point, the defense objects to Zoom testimony and asks for a dismissal of the charge instead because the witness is not here to testify. The court rule that Mr. Kaplan is referring to, of course, is XCR 6.006, which refers explicitly to its civil equivalent.
This right here is a constitutional law moment, and the defense attorney is playing chess while everyone else is playing checkers. He just invoked the confrontation clause of the Sixth Amendment, which guarantees a defendant the right to face their accuser. He's arguing that Zoom testimony limits cross-examination you can't see. Body language, you can't see if someone's coaching the witness off screen, and he drops the kicker. The witness isn't out of state for work, she's on vacation. The prosecution could have scheduled around this. That's not the defendant's problem. Will the judge agree? Watch closely.
NCR 2.407. 2.407 lays out factors for your honor to consider when allowing Zoom testimony versus not. A couple of those key factors here are the opportunity for full and effective cross-examination. As the court knows, a transcript is produced, and say we get to trial, the witness is not available then, and the government wants to proceed just on a transcript. That's a confrontation issue, and today is not a full and effective opportunity for me to cross-examine this because I can't see her body language. I can't see if she has papers on her lap or on the table. I can't see if there's someone behind the camera coaching her testimony. And so cross-examination is therefore limited when we have Zoom testimony. Another one of those factors is whether there is physical liberty at stake. Obviously, Mr. Fonville is in custody and his physical liberty is at stake in this case. And finally, another key factor is the convenience of producing the witness. Ms. Fisk doesn't live out of state, doesn't work out of state, she is on vacation, and that's something that the government should have planned around at the PCC stage when we were scheduling this exam, rather than on the day of the exam. So for all of those reasons, we would ask for a dismissal in lieu of a testimony.
Thank you. Yeah.
There, the Sixth Amendment confrontation right is a trial right, not a preliminary examination right. The U.S. Supreme Court has so held on many occasions. Now, the Michigan Supreme Court devoted an abundance of effort in devising this rule, which is MCR 6.006 parentheses 4. And I can repeat what I said earlier, but the court gives you discretion, Supreme Court gives you discretion. Now, let's assume that Judge Oakley decides, let's have the witness. All right, case dismissed without prejudice. He'll be rearrested, he'll be rearraigned, and we'll try him then. Judge, I don't see any prejudice in the experienced attorney who cross-examined the witness.
All right. Anything else?
Nothing further.
All right. Thank you for your arguments. I'm going to allow the testimony today by Zoom. Ms. Fisk, can you raise your right hand for me? Do you swear or affirm tell the truth, the whole truth, nothing but the truth today?
I do.
All right. Looks like you can put your hand down, ma'am. Looks like you're in an automobile.
I am.
Are you alone in that automobile?
I am not. We're on our way
Okay.
back to Michigan.
Say that again.
We're on our way back to Michigan. We're in
Okay. All right. So I'm assuming your driver has nothing to do with this case or your employment?
No, he does not.
Okay. All right. Are we ready, Mr. Kaplan? Go ahead.
Thank you, Brian. Judge, I missed it. You swear in the witness.
I did.
Thank you, Judge. Good morning, Ms. Fisk. Can you see me?
Good morning.
Can you see me?
Not great. No, I can't actually.
Should I move? I go to the
Try the podium.
Ms. Fisk, can you see me?
Yes, I can.
What do you do? I know we've been Steve Campbell with the prosecutor's office. Ms. Fisk, where are you employed?
Meyer in Belleville.
How many years have you been working in Myers?
34.
What street?
Pardon me?
What street is the Meyer located on? The store.
Van Buren Town.
What is your current position with
I'm
Meyer?
sorry, could the witness repeat her last answer for audio file?
Ms. Fisk, give me that address again, please.
The address is 9701 Belleville Road, Van Buren Township.
Thank you.
What's your current position, Ms. Fisk, with Meyer?
I'm a store detective.
Can you estimate for Judge Oakley the number of cases you investigated involving shoplifting at retail stores?
In 34 years,
Are
I couldn't even guess.
we talking hundreds, thousands? What are we talking?
Oh, yes.
I'd like to take you back in time to April 29th of this year, 2026, at about 2 p.m. Were you working?
I was.
Did you have the opportunity on that day to meet a gentleman or see a gentleman named Joseph Fondle?
I did.
Did you see Joseph Fondle?
Pardon me?
First, see Joseph Fondle.
Objection, there's a lack of foundation as to how this witness could identify any individual as Joseph Fondle.
That's a cross-examination. She could testify, she knows them, and
It'll work for Cross. Go ahead.
thank you. Regarding Joseph Fondle, where did you first see him on April 29th, 2026?
In our liquor aisle.
Where were you when you saw him in the liquor aisle?
I was in our camera room.
Describe the liquor aisle to us.
It's an aisle, several feet long with liquor.
Now, am I saying was your store giving away liquor to people?
No, they weren't.
You said that you were able to observe this through surveillance. Can you describe the surveillance to us?
It's closed.
Go ahead.
Pardon me?
Go ahead, describe it.
It's closed circuit television. We have cameras throughout the entire store.
Were the closed circuit televisions working on this day of April 29th? Were they
Yes.
functioning properly?
Yes, they were.
How do you know that, Ms. Fisk?
I was working them.
Ms. Fisk, if you saw Joseph Fonville again, do you think you'd recognize him?
I would.
Judge, how does she look around the courtroom, you know? Look around the courtroom.
Well, she's looking at everything you're looking at on that screen in front of you.
Look around the court and tell us whether you see Joseph Fonville.
I'm having a hard time seeing in the courtroom.
Can we show the council table?
I don't have the ability to do anything with this.
I can't zoom this screen actually.
I think it's zoomed in as much, the whole courtroom is zoomed in as much as it can.
Yeah, this is what we got.
That's the main courtroom.
That's helping a little bit.
And then do the other one.
I mean, I'm terribly sorry. I can see two people, but I can't see it to.
Is there any way to magnify?
I am going to object to identification.
She's got it zoomed as much as it'll zoom. So, hold on, God. It's zoomed as much as it'll zoom. Go ahead.
Going to object to identification at this point in time. I think all the court has done, all the court can do in this particular instance is literally zoom in on my client, and that is incredibly suggestive as to who this witness is supposed to identify in the courtroom. It also looks, based on the portrait orientation of Ms. Fisk on Zoom, that she is on a phone, which is a small device that's also supported by the fact that she is in a car. That's a small device. She said she can't zoom in. I expect that her ability to see, even though the court has zoomed in on my client, her ability to see is limited. Any identification would be incredibly suggestive and unreliable, and so I ask that the court decline to make it.
Well, of course, counsel presupposes that she knows my case. I might have another witness who can identify. I would like to proceed with this witness.
Go ahead.
What she knows.
Go ahead.
Ms. Fisk, can you describe the person you saw on CCTV?
A black male, dark glasses, like black rimmed glasses, wearing all black.
Had you seen him before at your store?
I had not.
What did he do, if anything, while he was in the liquor aisle in Meyer?
Pardon me?
Man, do while he was in that liquor aisle at Meyer?
He selected liquor and placed it in his cart, and he selected liquor and concealed it into his coat.
Can you tell the judge the number of bottles of liquor this person selected?
He selected 7 total bottles while in the liquor aisle.
What type or kind or class of liquor is involved?
Tequila.
You know what those bottles were selling for on that day of April 29th?
I wouldn't without referring to my report.
Judge, I have a report here. It's on page 18 of the police report. Would it refresh your memory? You saw the amount,
Yes.
the retail amount?
The amount for each bottle would be itemized in the section of evidence.
Total is shown on page 18. Is that a total that you rely on? The
Yes.
total retail sale amount?
That also includes the watermelon and the chips. That's just not the liquor.
Right. Can you show an amount, 6 products for $377.82, $377.82. Does that refresh your memory?
Yes, except that's 9 products.
9 products, $377.82.
Yes.
Well, what did the gentleman do with the liquor? Did he pay for it?
No, he did not.
Did he try to pay for it?
No, he did not.
Did he tell anyone that it was his birthday and he wanted free liquor?
No, he did not.
Want the store to give away the liquor?
Pardon me?
Want the store to give away the liquor?
We do not give away liquor.
You have opportunities to pay for the liquor.
He did.
Explain to us.
After he concealed the liquor on his person, he proceeded to the front of the store to our self-checkout lanes. And he actually placed the bag of chips and the watermelon into a Meyer bag without scanning them as well and walked out the grocery doors.
Does anybody give permission to take the products, merchandise, and not pay for them?
No,
Are there any impediments for him paying for them, such as, had there been some type of explosion where he couldn't go buy a cash register?
pardon me?
Sure, was there any reason why a person could not have paid for that merchandise?
No, no reason.
What does he do with the merchandise?
The liquor he concealed into his coat, into his shirt, and the watermelon and the chips he put into a Meyer bag at the register.
Ms. Fisk, do you know whether he stayed in the store or left the store?
No, he exited the store.
Are you able to tell the judge where he went when he exited the store?
I can. He went to the passenger side of a SUV. I believe it's blue in color.
What did he do then?
They left the property.
Any payment by him at that point?
No,
Did he come back the next day and say, oh, sorry, I forgot to pay?
no.
Are you able to tell us the brand of the tequila? You know,
I can't verbatim, but it would be listed in the evidence, the bottom of my report.
thank you, Judge. Nothing further.
Cross, Ms. Munger?
Ms. Fisk, you say that you were in the camera room at Meyer, is that right?
Yes,
Were you, so when you saw, everything you saw that you just described on cross-examination, you saw on CCTV?
correct.
And were you watching that CCTV in real time, or did you view it after?
In real time.
Did you ever leave the camera room and see, the suspect of the retail theft with your own eyes?
I didn't want to lose as observation.
So it doesn't help.
I didn't know.
Did any employee at Meyer, to your knowledge, intercept the suspect before he left the property?
My greeter attempted to stop him because the electronic alarms went off on his exit.
But no one successfully stopped the suspect before they left the Meyer property, right?
He refused to stop for her.
So that's no.
No.
You said that the suspect got into a blue SUV.
Pardon me?
You said the suspect got into a blue SUV.
Yes, I believe it was blue. He was the passenger.
What did you do next?
I contacted Van Buren.
And you were not able to give them a license plate of the SUV, correct?
No.
No further questions.
One question, Your Honor. Ms. Fisk? No, but when you say you contacted Van Buren what?
Police department.
Thank you, Judge.
No recross, counsel. All right, Ms. Fisk, thank you. Travel safely.
Thank you. Have a great day.
You as well, ma'am.
One of the people called Tori Pearson.
Pearson?
Yeah.
Ms. Pearson, all the way up front, please. Ma'am, would you raise your right hand for me? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today?
Yeah.
Come on, right up here. I'm going to stick you in this chair. Watch your step on this ramp right here. Make yourself comfortable in that chair. And after you sit down, would you state your name and spell your last name, please?
Tori Pearson, P-P-A-R-S-O-N.
Thank you, ma'am. Mr. Kaplan.
Ms. Pearson, good morning or afternoon to you. My name is Steve. I'm one of the prosecutors here in Wake County. Nice to see you. Are you employed?
Yes,
Were you working on April 29 of 2026 in the early afternoon?
yes.
Where were you working on that date and approximately?
On the north side, on the north side of Myers,
Which
north
Myers?
side,
Which Myers School?
Belleville,
On April 29, how many years or months had you worked at Myers?
I'm going on 5 years,
Are you part-time or full-time?
part-time.
You like to work?
Yes,
Ms. Pearson, what were your responsibilities on April 29 of this year at around noon?
I'm a greeter slash, if someone steals something, our alarm goes off. I attempt to stop a person. If the person doesn't stop, or if they do stop, I go to the phone, I call our detective, tell the detective what the description of the person is, and they take it from there.
Ms. Pearson, the judge clearly knows what a greeter is, but define the responsibilities of the greeter.
A greeter is, we stand at the door if someone attempts to try to take something out of the store when their alarm goes off. We have to ask them to stop. Sometimes they stop, sometimes they don't.
Ms. Pearson, did anything unusual happen that day at about 12 or 12:30 at the Myers store where you were working as a greeter?
Yes,
What happened that was unusual?
the alarm went off.
What does it mean when the alarm ignites?
So the alarm goes off, I need to check that person and see what is in their bags.
What causes the alarm to detonate?
Sensors. Sensors. That is-
I'm sorry. What are the sensors gauging? What are they measuring? You said the sensors.
It's sensors in different things, different products that Myers have. And when the sense, if you take it and it hasn't been, deactivated, that usually lets us know that someone might have taken it. And so we have to check your receipt to see if you actually bought the product or not. Match to see if reason why the sensor.
Did you have any type of encounter with a person at Myers store while you were working as a greeter on April 29?
Yes,
Tell the judge what type of encounter you did.
the sensor, when the sensor go off, I ask whoever the person is to stop. Sometimes they do, sometimes they don't. That particular day, I asked the person to stop on several occasions and he didn't.
How far were you from this person when you asked him to stop?
They had to go past me.
When he passed by you, how close were you when you first noticed him?
A couple of feet.
Is this a man or a woman?
Okay.
Is it black or white man, Hispanic, Asian?
Black.
Had you seen this person before?
No.
If you saw him again, you think you'd recognize him?
I don't know. I can't say until I actually see the person.
Can you look around the court and tell us whether that customer is here?
No.
You saw a photo of this person? Think it might refresh your recollection?
If I can see the photo.
You're gonna be able to witness.
Sure.
Trying to find the page here for council. Let's mark these as proposed exhibits 1 and 2.
It's fine.
May I approach?
Sure.
I'm giving you 2 photographs marked as proposed exhibit 1 and 2. I'd like you to look at those and see if they refresh your memory as to the appearance of the customer.
I remember this actually.
Now, looking around the courtroom, do you see that person?
100% sure.
Well, how sure are you?
As far as that picture of that guy, but if you're He had like glasses on where nobody even had glasses on with him.
Now, the person that the sensors went off, did you have a conversation with him or her? With him?
Yes, I tried to stop him. Didn't tell him to stop on 7 occasions he wouldn't stop.
What did you do when he wouldn't stop?
Our procedure is to call our detective, give the detective the description of what the person looks like, and they can be able to get on the camera cam.
Do you know whether this person had any merchandise with him?
I can't say 100%. It had to be what it says before.
Did this person make any effort to pay?
No,
Did the person offer any explanation for nothing?
no, he just kept walking.
Did he respond to your questions?
No,
You think he heard your questions?
yes.
Thank you. Nothing.
Counsel?
Dismissed without prejudice. Now, before you celebrate for Mr. Fonville, understand what that actually means. Without prejudice means the prosecution can refile these exact same charges. This isn't over. The greeter couldn't make a confident ID. The store detective was on a phone in a moving car, and the identification procedure itself was called incredibly suggestive by the defense. The case fell apart today, but the prosecution gets another shot. The real question is, will they take it? And if they do, will the evidence hold up next time? That's the cliffhanger nobody's talking about.
No questions, that's what I'm saying.
Ma'am, you can step down. Thank you for your time. Watch your step on my ramp.
Judge, we didn't mean to squander your time.
It's all right.
We're surprised by the testimony for the report. Obviously, the case has to be dismissed at this point without prejudice, unless your honor would grant us, should have asked to be adjourned earlier. So the case, I'm sure, will be dismissed without prejudice. We will refile it.
You are correct. Dismiss without prejudice.
Thank you.
Mr. Martin, are you ready on Stringer?
Yeah.
Come on up. Back on the record.
Thank you, Judge. Member of the service, Carrie Bond, please provide me to the door representing Mr. Stringer. Stringer, stay over me one more time.
Yeah, sure.
And Judge, after discussing my client's options with her.
Yep.
Ability to pay is limited right now.
Sure.
So talk about ability to do work program.
Yep.
8 days by July 15th. And Ms. Stringer will go with that option.
Okay.
Did you just want some clarification about this $300 restitution?
Yeah.
You said a 12-month non-reporting probation and, 300 must be paid by the end of probation.
Well, I want it paid before then if she can, but I understand she's not working right now. Right.
Or there's not a specific deadline that the court is.
I mean, I'll put her on a payment plan. What do you want to pay? How much? How often? Make some kind of commitment and we'll set that up. Okay. And then you can always pay it off early. And if you get a really good job before you're done with your 8 days and you want to pay money instead of doing the days, we'll convert there. All right.
So I think the whole sentence would then be 12 months non-reporting probation, $300 restitution on a payment plan, 8 days in the work program, first 4 by June 12th, next 4 by July 15th. That's it.
First 4 by when?
You said June 12th.
Okay. I thought you said June 4th. I'm like, no, that's too quick. Okay.
June 12th, and next 4 by July 15th. No other terms or conditions.
Yeah. Stay out of trouble. That's what probation's all about. Okay. Anything else?
Nothing.
All right. Go downstairs, make arrangements for that $50 a month. And we'll always take money early so you can get out from under that quicker. You're welcome. You're welcome. Always a pleasure, counsel. Shutting down.
Yes.
Joe, you want to turn that TV off?
Yep.